Hi, and welcome to the studio here at the Oklahoman. I'm Don Mecoy. I'm the managing editor here at the Oklahoman, and I'm joined today by David Dishman, one of our business reporters. Welcome.
Thank you, Don. Thank you.
I understand the state Supreme Court has issued a ruling on this law deals with the liquor business. Tell us a little bit about that.
Yeah, so people will remember a few years ago we voted on State Question 792, and that we approved, and that changed the alcohol industry as we kind of know it. People recognize that that we've got wine in grocery stores and convenience stores, cold beer in liquor stores. Well, along with that came a change to the distribution. And that distribution was then changed again when Senate Bill 608 passed or was signed into law last year. Now that was challenged to be unconstitutional. It worked its way through the courts. The Oklahoma Supreme Court ruled today, made their decision that yes, it was unconstitutional. So that will now be no longer.
So what's at issue here is the relationship between the manufacturers of the product and the wholesalers that distribute it on to the retailers here locally.
Correct, and that's what's been in flux for the last couple years. A manufacturer of an alcoholic beverage, whether it's Jim Beam or Jack Daniels or Tito's Vodka, they have to get that product to where it can be sold to consumers, to your liquor stores, to your grocery stores, or whatever's being sold. Under current law, up until today, those products could designate a single wholesaler to distribute their products. Well, 608 had requested that or laid out that the top 25 brands by retail sales would be required to use every wholesaler in the state. So if you wanted to work to sell some of that, if it was a top 25 brand, then you could. Well, this was controversial in that middle tier because some of the manufacturers prefer to use just one wholesaler because they can track their products better. They can have some better quality control. But the wholesalers, if they don't get that exclusive contract with one of those brands, then they can't profit off of it. And then retailers, they prefer to have multiple wholesalers that they can buy from. So if they run out of, again, Jim Beam, Jack Daniels, Tito's on their shelves, they can call up any other wholesaler and they can come deliver it, as opposed to just one wholesaler who would have to deliver it.
For me, as someone who might be going in to buy a bottle, since this is kind of up the supply chain, sounds like it wouldn't have a tremendous impact on me when I walk in my local store to get something.
Most people won't notice a huge change. This has been debated and fiercely debated, and that's why it worked its way up to the Supreme Court, because these companies and these brands and these manufacturers, they all argue that it has a huge effect on the consumer. Well, if you've been in a liquor store, and since we've changed our laws back a couple years ago with State Question 792, you'll know that you can still find most liquor brands in a liquor store. Those liquor stores or a grocery store, convenience store that's selling strong beer or wine now, they may have to work a little harder or plan out things a little bit ahead to make sure that they keep their shelves stocked. And maybe you run into an instance where somebody ran out of product for a short time, but for the most part, consumers won't see much of a difference. It's very much a business ruling that will affect the businesses in that middle tier of distribution.
Okay. Well, I know you've already got a story posted on Oklahoman.com about this Supreme Court decision, and David will have a more detailed story in the paper tomorrow, and again later today on Oklahoman.com. We'll update that story, and he'll continue to follow this as we go forward with these changes in our liquor laws. Appreciate you joining us today. Thank you very much.